my understanding that the parties have had some further discussions and have resolved the matter?
I believe so, Your Honor. Donald F. Burke Jr. For the plaintiff. If I could speak for the parties at this time, we've agreed to resolve the matter for checking the amount of $172,000 to the plaintiff. The issue of fees is to be determined.
Mr. Middleton?
Judge, I've got a different take on that. Sure. What he's saying is factually correct. The case is settled for $172,000, subject to plaintiff's counsel making an application to the court for counsel fees. So that's really the resolution that has been set forth at this point. You agree, Mr. Burke?
Yes.
Okay.
Yes.
All right.
Okay. Mr. Middleton, you've spoken to your attorneys about this?
I've spoken to them, and on our I believe, fees and payments and everything are covered.
So you understand that they're going to make an application to the court, but as I understand it now, that there's a check that's going to be written to you and to your attorneys.
And to the attorneys.
Yes. To the attorneys to resolve the matter. Is that your understanding?
That is my understanding. That I don't believe there are any additional costs to
Is that
That's true.
That is true.
Net to him?
That is true.
Okay.
That's
Net before taxes, that check will go to C.
That's I believe I understand that.
Have the attorneys answered all your questions with regard to that?
I believe so. Yes.
Okay. And do you have any questions at this point of myself, your attorneys, or of the defense attorneys regarding that settlement?
No.
You understand it?
Yes. I do.
You're doing this voluntarily?
Yes.
Nobody's threatening you, forcing you, coercing you in any way to settle the matter?
No.
Okay. You're doing it voluntarily?
Yes, sir.
Okay. We're in the midst of a trial, or at the beginning of a trial. It's supposed to go for another 2 weeks. And that's a very valuable right. I was just speaking with the jurors, the incoming jurors downstairs, and as I tell them, it's a very valuable right that we have to have a jury make that decision. By settling it this way, you're giving up the right to a jury trial. Do you understand that?
Yes, I do.
And that's what you want to do?
Yes, sir.
Okay. Mr. Connell?
Judge,
is that your understanding of the settlement?
In terms of the authorization, my authorization to settle the case, it's the city of New Brunswick is a self-insured entity and member of a joint insurance fund, the Middlesex County Municipal Joint Insurance Fund. I want to indicate for the record that the Mayor Cahill did not approve this settlement, did not favor this settlement. He has approved it, subject to what I'm going to tell you. He was not in favor of settling this case. He wanted the jury to decide this case. Director Caputo felt exactly the same way. He was not in favor of settling this case. In light of what happened yesterday, and in light of a pending application before the court that this court hasn't even ruled upon, maybe you'll have some comments with respect to that. But the joint insurance fund was presented with the facts and circumstances of this case. The fact that a motion for a mistrial is now before the court. If that motion was granted, we'd be starting all over. That if it wasn't granted, we believe that this jury would have been tainted to an extent that there was going to be an appeal no matter what happened in this case. If the city was successful, I'm confident the plaintiff would have appealed. If the plaintiffs were successful, I can guarantee you we would have appealed the case. And therefore, there is going to be extended costs incurred by our law firm and potentially other law firms in dealing with the appeal, because the appeal would have dealt with issues that had been decided by the court before you, Judge Bergman's decisions, which would impact it, bringing those other lawyers back to be involved in that appeal. So from a financial point of view, the JIF decided that it was prudent for them to do that, and they've got the right to settle the cases, notwithstanding the feelings of the public entity. And based upon those decisions that were made by the JIF to settle this case, the mayor and the director, they understand that, and they, even though they didn't favor the settlement, they have agreed to put their imprimatur, their approval of it, to the extent that it's being done for a cost savings basis. And I think I'd like to have the court place on the record the applications that were before the court at the end of the day yesterday, and how you feel about that.
I mean, the court would have considered any application for mistrial, and certainly we do that with great reservation, but I know that there was a heated exchange on some of the issues of the admissibility of evidence yesterday. I don't know if everybody did the homework last night assignment, but I was certainly going to consider a curative instruction if the case law warranted that. But I think that we usually find that if the parties can resolve a matter, it makes for a better settlement. And so I want to thank everybody for making that effort. I know that the city is still not satisfied with that. Even with the resolution, but as I understand it, they have agreed to that resolution.
Yes, I am authorized to settle the case based upon the agreement between the JIF and the public entities, and all the public entities that comprise this large JIF of approximately 38 towns. But as a result of that agreement, they have the ultimate authority to resolve cases, even though they're dealing with the self-insured city of New Brunswick. And the city of New Brunswick obviously was consulted throughout this case in terms of the resolution, as was the JIF. It's a complicated method of resolving cases, but it's pursuant to we'll call it an insurance agreement, the self-insurance agreement that all the entities are involved in. So, you know, we have the authorization to settle the case.
I want to thank everybody for making the efforts to resolve the matter. Good luck to you, Mr. Middleton.
Thanks.
We're going to just ask you to sign a stipulation that lets us take it off the court's computer. Yes, both sides to sign off on that.